Hello, guys. Let's start off with institutional framework family courts. In 1984, the Family Courts Act was enacted for creation and functioning of family courts with expertise to deal with matrimonial and family law matters. Now, as you know, there are civil courts and criminal courts or session courts in India, right? Civil courts have the jurisdiction to deal with civil matters. Criminal courts have the jurisdiction to deal with criminal matters. So, when I say family courts, that means they have the jurisdiction to deal with family law matters, which includes matrimonial disputes. So, the Family Courts Act 1984 was enacted so that family courts can be established, and the powers, duties, and functioning of those courts were also defined so that they can deal with the family law matters. Act is procedural. Now, this act is procedural. That means it lays down the procedure of the functioning of family courts, how they are to function. Does not override the substantive family laws, and accordingly rights and obligations of parties to disputes are based on family, personal, or matrimonial laws. So they are only established, and their functioning of how they have to function, that all is given in the Family Courts Act, which is a procedural law. Please remember, Family Courts Act is a procedural law. That means it will only lay down the procedure of functioning of those laws, and it has to be combined with the substantive law. That means substantive means substance. Okay, so it has to be combined with the substantive family laws of their particular personal or matrimonial laws. So the HMA, HSA, all these, for example, they are the substantive family laws. Okay, and now how will that law be applicable? That is in the procedural law of Family Courts Act. This you can draw the analogy with IPC and CRPC for an example, or BSA and BNSS for the new laws that have come into force, or the civil laws, TPA, Indian Contract Act, with the CPC, that is Code of Civil Procedure. So TPA, Transfer of Property Act, Indian Property Act, Indian Contract Act, Sales of Goods Act, all these are substantive laws. They prescribe that for such act done, what would be the liability. If it is a criminal law, it will tell you what is the punishment, what are the ingredients or elements that have to be satisfied or fulfilled to constitute that offense or to constitute that liability. And if all those elements are combinedly fulfilled, then you can award that penalty, punishment, sentence of imprisonment, or the compensation or the damages to be paid of such and such amount, which may not exceed such maximum limit. ऐसा दिया रहता है ना एक्ट्स में. सो वो बताएंगी कि कौन सा एक्ट हुआ है और उसकी पनिशमेंट या कॉम्पनसेशन क्या हो सकती है, एंड द पर्सन इज लाइबल इन व्हाट वे एंड टू व्हाट एक्सटेंट. बट how that law will be applicable, how that law has to be conducted or interpreted, that all is given in the procedural laws. How and what evidences have to be submitted, how the documents have to be placed on record, who all will be the eligible witnesses, ठीक है, and how they have to be called or summoned in the court. ये सारा कुछ procedure है. That is in the procedural law. How the family courts have to deal with such matter, how they have to apply those substantive laws in a particular dispute that has come in their court, how the parties to the dispute will be administered justice, because why the parties are coming or why they are filing the case, the ultimate goal is to get justice, right? And the aim of the courts also is to provide justice to the parties. And there is a very famous saying that procedure is the handmaid of justice. Handmaid, HANDMAID, means procedure has not to be read strictly, okay, and it can be molded or read liberally so that justice can be administered to the parties concerned. This is the main goal, and to achieve it, it may not to be read so strictly. Okay, this is a very famous saying. In every procedural law it is applicable. During 1980s, 1990s, many family courts were established in most major cities, and matrimonial and family law cases were shifted from district, civil, and criminal courts to the newly created special courts. Now, why criminal? Because, for example, Section 125 CRPC is a criminal legislation. So, that may go in a criminal court. Or if a lady or a wife has died due to the demand of dowry death, the proving of which is given in Indian Evidence Act, right? So that will again go into criminal court, right? So criminal courts यहाँ पर इसीलिए बात आती है. डिस्ट्रिक्ट, सिविल और क्रिमिनल कोर्ट्स से जो भी फैमिली लॉ केसेस थे वो कहाँ गए? फैमिली कोर्ट्स में, कि आप उधर लाओ एंड यू डील विद दी अदर केसेस, बिकॉज एज वी नो court's time is very precious and there is a long pendency of cases. So to reduce their burden, family courts were created with many distinct features and goals, including reduction in formality and intimidation in litigation processes, speed in justice delivery, facilitation in conciliation and settlements. Now, since it is family related matter, right, so it is not necessary that we fight rigorously or we play the dirty game of court politics, क्योंकि जब आप इन्वॉल्व हो जाते हो तो बहुत उल्टी सीधी बातें बोली जाती हैं. सच में बहुत डर्टी गेम होता है कि बिना सर पैर का जो इल्ज़ाम उस बंदे में होगा भी नहीं, जो प्रॉब्लम या खामी, जो बुराई उस बंदे में नहीं होगी, वो भी उसमें पॉइंट की जाएगी जस्ट टू मेक योर ओन केस स्ट्रॉन्गर, right? And then the other person had to prove that he is not that kind of individual. So it is a very dirty game of blames and blames. So it may happen that the family, if with a cool mind allowed to sit together face to face, there is an emotional bond present, they may reconciliate, means आपस में बात करके वो मैटर को सुलझा सकते हैं. They may reach to an agreement in presence of a neutral third party, जिसका कोई bias नहीं होगा towards any party to the suit. Okay, he will be a neutral one, और वो guide करेगा कि आप आपस में बात करो शांत दिमाग से, लड़ाई झगड़ा नहीं करना है, लेकिन इस प्रॉब्लम का solution आप लोग खुद निकालो. That is conciliation and settlements out of the court settlement. कोर्ट रूम के बाहर जाकर एक ठंडे इन्वायरमेंट में और एक कंफर्टेबल प्लेस में बैठकर कोजी से यू ट्राई टू सॉल्व द डिस्प्यूट अमंग योरसेल्व्स ऑन योर ओन. स्पीड इन जस्टिस डिलीवरी, एज आई टोल्ड यू, टू रिड्यूस द बर्डन ऑफ केसेस और स्पीडी जस्टिस. एंड फॉर्मेलिटी एंड इंटिमिडेशन, जितनी भी फॉर्मेलिटी होती है नॉर्मल केसेस में, उसको रिड्यूस करना फैमिली कोर्ट्स या फैमिली केसेस के कंपैरिजन में, दैट वाज द aim. The personal or family law subject matters that fall within the jurisdiction of family courts. Now, what is the subject matter or jurisdiction of family courts? Let us read. Nullity of marriage. Nullity means to declare anything as null and void. Void matlab to cancel its existence. Valid means it exists. It exists lawful in the eyes of law. Right? It exists as something valid. And void is the opposite of it, means cancel कर देना उसकी existence. हम नहीं मान रहे कि ये चीज़ थी. So nullity of marriage means हम नहीं मानेंगे कि उन दो persons के बीच में कभी भी शादी हुई थी या कभी भी marital relation बना. उनके बीच में कोई matrimonial relation बना या there was a marriage between those two people, we are not going to consider that. So we are cancelling the existence of marriage between those two persons. There is a difference between nullity of marriage and divorce. In divorce also, you cancel the marriage बट यू डोंट कंसिडर इट टू बी नॉन एग्जिस्टेंट. वॉइड मतलब कि वो कभी था ही नहीं. हम उन दोनों के बीच की शादी को वैलिड नहीं मान रहे. नाउ सिंस इट इज इनवैलिड, it is running contrary to the law, so we are nullifying it. We are cancelling its existence. We are cancelling something which runs ignorant or contrary to the provisions of law. So that is nullifying. Okay, like in Hindu law only one marriage is allowed. Now if a man marries second person or second woman while his first wife was living, okay, so the second marriage is to be declared null and void. Because that runs contrary to the law, we have to cancel its existence. Right? We have to go according to the law. So anything which is contrary, we have to cancel it. So that is nullifying the marriage. लेकिन divorce में आप उस marriage को nullify नहीं करते हो. You recognize that there was a valid marriage between those two people, but now because of some disagreements, or they are not able to survive together because of some fights or difference of opinions between those two people, they are not able to match. They are not considering them to be compatible enough that they can spend further more years of their life together. Right? It will only bring them more misery than good. वो उनको और दुख ही देगा. So you cancel that, you break down that valid relation, and you allow them to live separately, to lead their lives in different paths, independent paths as they wish to. That is divorce. Remember, divorce is different from nullity. Nullity में जो चीज़ आप cancel कर रहे हो वो कभी valid था ही नहीं. That was contrary to law. But divorce में what relation you are cancelling, that was valid. आप एक वैलिड चीज़ को ख़त्म कर रहे हो और उन दोनों को कह रहे हो दैट अगेन वैलिडली यू कैन लीड योर इंडिपेंडेंट पाथ्स. आई होप आई वॉज एबल टू कन्विंस द डिफरेंस बिटवीन दीज टू टर्म्स. Restitution of conjugal rights. Restitution means to restore something. Conjugal rights means marital rights. Okay, so if what is the basic thing post marriage? Girl goes to the groom's house and they start living together. And that house is called the matrimonial home. ठीक है, where the couple lives post marriage, that is matrimonial home. Right? So that is the basic thing. Then procreation, basic element. To live, eat, reside together, right? To sleep together, that is conjugal right. So restitution of conjugal right means if any of the spouse, either the husband or the wife, is living separately in a different place without telling or informing the other spouse of the reason to do so. अगर जॉब है, वैलिड रीज़न है कि हम जॉब की वजह से दूसरे शहर में शिफ्ट हुए हैं और ये बात दूसरे स्पाउस को भी पता है. So that is a valid reason. That is not a ground for divorce basically. लेकिन अगर देर इज़ नो स्पेसिफिक रीज़न, उसका मन ही नहीं करता उसके पास आने का, साल में एक दिन आती है और बार बार बुलाता रहता है हस्बैंड, बट शी इज़ नॉट टेलिंग एनी रीज़न, बस उसका मन नहीं करता उसके साथ रहने का, तो हस्बैंड कैन फाइल अ प्लेंट और पिटिशन इन द कोर्ट कि आप कॉन्जुगल राइट्स को रिस्टोर करवाइए. ये जो मेरी बीवी बिना किसी वैलिड रीज़न या एक्सप्लेनेशन के मुझे छोड़कर कहीं और रहती है सेपरेटली, आप नाउ इट इज़ माई कॉन्जुगल राइट एज पर द मैरिटल रिलेशन शेयर्ड बिटवीन अस कि वो मेरे साथ रहे. इधर शी अफोर्ड्स एन एक्सप्लेनेशन टू द सेम, और आई विल गो टू हर प्लेस और शी कम्स टू माई प्लेस, बट वी हैव टू लिव टुगेदर. सो दैट इज़ द कॉन्जुगल राइट एंड रीस्टोरिंग इट. रीस्टोर वाई? बिकॉज आप ओरिजिनल पोजीशन पे लाओ ना कभी तो वो लोग साथ रहे होंगे, बट क्योंकि उसका मिसमैच हो गया तो वो छोड़कर चली गई और अब उसका मन हट गया, नहीं मैं नहीं रह पाऊंगी उस आदमी के साथ, ऐसा. सो यू रिस्टोर इट. एज आई सेड, यू कैन सी द एक्सप्लेनेशन, सेम इट इज़ रिटन इन द बुक. कोर्ट आस्क द स्पाउस टू रिटर्न बैक टू द कॉमन मैट्रिमोनियल होम. इफ़ द ग्राउंड्स आर सेटिस्फाइड कि हाँ कोई रीजनेबल कॉज नहीं है, आफ्टर हियरिंग बोथ द पार्टीज, इफ द कोर्ट थिंक्स फिट, तो ही मे ऑर्डर दैट यू कम बैक टू द मैट्रिमोनियल होम. ठीक है. जुडिशियल सेपरेशन मीन्स मैरिज इज़ नॉट डिजॉल्व्ड बट मैरिटल राइट्स एंड ऑब्लिगेशंस को सस्पेंड कर दिया जाता है, रोक दिया जाता है. जुडिशियली यू आर सेपरेटेड इन द आइज ऑफ लॉ और बाय द कोर्ट यू आर सेपरेटेड, बट इन एक्चुअल योर मैरिटल रिलेशन हैज़ नॉट कम टू एन एंड. Your valid marital relation will come to an end only if you two are divorced. Okay? Validity of marriage means to declare your marriage to be a valid one. That can also be declared like there was an inter-religion or inter-caste marriage and your families are pressurizing you. So now you go to the court to declare your marriage as a valid one. Or again, if your husband has married second, not your, but okay, take if a woman's husband has married for the second time while she was alive, while his first wife was alive. So now she may go to the court to declare her marriage valid, so that the second marriage which he has performed, that will automatically be declared invalid or contrary to law, and hence it will be nullified. Right? Then matrimonial status. Matrimonial status means of husband and wife. I am the husband, you are the wife, to declare that status. Disputes regarding property of either of the parties or joint property, like the succession of property. For suppose a wife is denied the share in the property of her husband post her husband's death. Why? Why she is denied? Because the husband's family is saying that no, you just go out. नाउ ये मेरे भाई का है तो अब मुझे मिलेगा, तुम्हारा कोई हक नहीं है इसमें, क्योंकि को पार्टनर्स कौन है, मेल्स ही होते हैं, तो हमें मिलेगा. और सब ने मिलकर, उसके जितने भी घर वाले थे उसने उसको मिलकर बाहर निकाल दिया. सो नाउ शी मे गो टू द कोर्ट टू आस्क फॉर द शेयर इन हस्बैंड्स प्रॉपर्टी, बिकॉज उसकी अर्निंग में भी उस पर डिपेंड हो, उसका मेंटेनेंस का फॉर्म वो हो. हस्बैंड इज़ नॉट अलाइव टू गिव हर द मेंटेनेंस, नो. सो अब कहाँ से वो अर्निंग लेगी? प्रॉपर्टी से. She may have at least a shelter to live in. Injunction means to stop something. Restrain order, okay? Arising out of marital relations. To stop somebody from remarrying, to stop somebody from harassment. Legitimacy of any person. Person here means child. To declare that a person is the legitimate child of the two people, of mother and father, or of the couple. And what is the point of declaring somebody as a legitimate child? Because if he is a legitimate child of the parents, then he will be entitled to the property and to the other benefits that the biological child of a parent of a couple is entitled to. Maintenance, everybody knows. Guardianship means guardian of a child. To declare somebody as a legal or natural guardian of the child, so that the child can be nurtured proper care. Custody of a child and access to any minor. The relevant statutes. Now these all were the disputes or the subject matter in the jurisdiction of Family Courts Act. Now what are these statutes? The substantive laws that go hand in hand with this procedural law. HMA, as the name suggests, codifies the marriage law of Hindus and deals with validity and conditions for invalidity and applicability of marriage. कि marriage valid कब होगी, marriage invalid कब होगी, that all is HMA. Special Marriage Act affords a special method of civil contractual marriage and divorce for all Indian nationals regardless of religion or faith followed by the parties. अगर स्पेशल सिर्फ रिलीजन का है, उसी रिलीजन में जो मैरिज होनी है, तो HMA या इस्लामिक लॉ विल गवर्न. बट इफ देयर इज इंटर रिलीजन मैरिज, तो स्पेशल लॉ चाहिए ना, बिकॉज यू आर नॉट प्योरली गवर्नड बाय हिंदू लॉ. हिंदू मैरिज एक्ट governs marriage between two Hindus, but if a Hindu is marrying Muslim, so you are not properly and completely coming under the Hindu law, isn't it? So there you have to be governed by the Special Marriage Act. ठीक है, irrespective of any religion followed by the parties, this is a special method of contractual marriage. ये कोर्ट में होती है. ठीक है. This act does not require customary religious rites or ceremonies of marriage to be observed. Just with 2 or 4 witnesses, you have to sign that contract, and it is a proper court marriage which is conducted. और court marriage में, as you know, कोई ritual या rites की ज़रूरत नहीं है. People can by themselves if they want, according to their choice, they can hold those ceremonies. Dissolution of Muslim Marriage Act explains the dissolution of marriage by women married under Muslim law and effects of renunciation of Islam by a married Muslim woman. So this basically applies on married women, Islamic religion, under which what would be the effects of dissolution, how they will or what laws they can avail to get their marriage dissolved, and if a Muslim married woman is renouncing इस्लाम को छोड़ रही है वो, तो उसके इफ़ेक्ट्स क्या होंगे. अब अगर आपने कोई चीज़ छोड़ दी, कोई लॉ आपने सपोज इस्लाम आपने छोड़ दिया, तो इस्लामिक लॉ will not be applicable on you, no, because you have left that. Islamic law was earlier applicable on you because of the fact that you belonged to that particular religion, but because you have left that, now it will not be applicable. So what will be the effects? Foreign Marriages Act deals with marriages of citizens of India living outside India. Indian Divorce Act relates to divorce of persons professing the Christian religion. Fine. 1869 का है ये Indian Divorce Act. इसमें not only Christians but सारे religions आते थे, because it says Indian Divorce Act. But post independence, when Hindu Marriage Act was made, it also governs the divorces of Hindus. So वो चीज़ वहाँ चली गई. There is a very slight difference between the grounds for divorce which are given in HMA and this Indian Divorce Act. If you read that, otherwise we will do. The Parsi Marriage and Divorce Act deals with marriage and divorce among the Parsis. What is the name of the religion which these Parsis follow? Try to find out. Muslim Women Protection of Rights on Divorce Act. The act deals with the matters of divorced Muslim women and governs their right to maintenance from their former husband. Why we need a special law for the right of Muslim married women who are divorced, and why we need a special law for their right to maintenance? Because under the Muslim law, they only have the right to maintenance for the iddat period, which is 3 months post divorce. After that, they are, besahara जिसको बोलते हैं, I'm not getting the word for it. Muslim personal law or application of Shariat Act requires the application of Islamic law code of Shariat to Muslims in India in their family or personal matters. Hindu Adoption and Maintenance Act codifies the legal process of adopting children by a Hindu adult and legal obligations to provide maintenance to various family members. So Hindu maintenance can also be claimed under HAMA, right? The name itself suggests, you can read it on your own, guys. Indian Christian Marriage Act regulates formalization of marriage among Indian Christians. Hindu Minority and Guardianship Act explains guardianship relationships of Hindus involving adults and minors. Now guardian will be an adult and किसको guard कर रहे हैं वो, that will be a minor. So the relationship between adults and minors and people of all ages and their respective property. Because it may happen that there is a minor जिसके parents मर गए, लेकिन now after parent he has that property, inherent कर दी उसने property, but as a minor he is not able to, or he does not know how to handle that property, how to incur income from that property, or how to manage it, right? So for those affairs a guardian can be appointed, जो कि उसका कोई near relative हो सकता है, या फिर कोर्ट कोई ऐसे पर्सन को गार्डियन अपॉइंट करेगा एंड ही ऑल्सो हैज़ टू रिपोर्ट टू द कोर्ट कि मैंने ऐसे ऐसे मैनेज किया. अगर वो गार्डियन इनजस्टिस कर रहा है तो द गार्डियन में बी चेंज्ड, ही मे बी डिस्क्वालिफाइड फ्रॉम दैट गार्डियनशिप, right? So guardianship is also a fiduciary trust relationship, of course, because the child is trusting you with all the affairs or all the needs that he may need, that he may require in the later stage of life. You are handling that property on his behalf, so that when he grows up or when he attains the age of 18 years, he can manage that on his own. He will take over, of course. Guardian and Wards Act, non-religious and universally applicable law regarding issues relating to guardianship of a child in India. Chapter 9 of Criminal Code, that is Maintenance. Protection of Women from Domestic Violence Act provides safeguards to wife or female live-in partner against domestic violence by husband or male live-in partner or relatives. Living relationship is as such not recognized in Indian society, but still the protection is given. When you will read this, you will get to know the basic difference between the two, living relationship and marriage. This law also provides protection to other women living in a household, including sisters, widows or mothers. क्योंकि सिर्फ वाइफ तो नहीं होती ना एक घर में. There is a mother, there is a widow, or there is sister, widow of a brother, right? So those other women can also claim protection under this law, because it says protection of women from domestic violence. It does not say protection of wives from domestic violence, right? So Muslim women, Protection of Rights on Marriage Act made triple talaq a cognizable offence and punishable. Now, one thing which I would like to mention in the above act, which is given in point number N, कि वाइफ मेंशन नहीं है. सो जो विडो है वो भी किसी की वाइफ रही होगी, बट उनके पति मर गए तो वो तो उन पर टॉर्चर ऑफ कोर्स नहीं ही कर पाएंगे, राइट? तो हो सकता है कि जो उनका ब्रदर इन लॉ है वो इस विडो पर टॉर्चर कर रहा है, तो अगेंस्ट द ब्रदर इन लॉ शी मे फाइल द केस एंड अंडर दिस एक्ट. दिस इज द मीनिंग. ओके, सेम फॉर मदर्स, कि उनका बेटा उन पर टॉर्चर कर रहा है, उनका भाई उन पर हरासमेंट कर रहा है. सो इन दैट सेंस प्रोटेक्शन ऑफ women from domestic violence. The family courts provide mandatory powers to the state government to set up family courts in cities and towns with population over 1 million and discretionary powers for areas with less than 1 million. So mandatory means compulsorily power है to the state governments that the cities or towns, क्योंकि ये सारा डेटा तो स्टेट गवर्नमेंट के पास ही होगा ना, फॉर देयर रिस्पेक्टिव स्टेट्स. तो जिसकी भी पॉपुलेशन 1 मिलियन से ज़्यादा है वहाँ पर मैंडेटली उनको फैमिली कोड्स बनाने हैं. और डिस्क्रिशन है उनका फॉर द सिटीज़ विद लेस देन 1 मिलियन पॉपुलेशन, वहाँ पर उनके डिस्क्रिशन है कि 2-3 सिटीज़ को कंबाइन करके एक फैमिली कोड बना सकते हो वहाँ पर, जिसका जुरिस्डिक्शन उन 2-3 सिटीज़ पे हो सकता है. दैट कैन कंबाइनली बिकम द पॉपुलेशन ऑफ 1 मिलियन, राइट? आपको सिटीज़ कंबाइन नहीं करनी है, बट एक कोड बना दो जिनका जुरिस्डिक्शन 2-3 सिटीज़ पे हो सकता है. सो दैट इज़ एज पर द विश ऑफ दैट स्टेट गवर्नमेंट, कि या तो उनको उस सेपरेट सिटी को सेपरेट फैमिली कोड देना है, या फिर 1 मिलियन पॉपुलेशन करने के लिए 2-3 सिटीज़ को कंबाइन करके उन सब का कॉमन जुरिस्डिक्शन एक कोर्ट को दे देगा. वो जैसे भी करे, वो उस स्टेट गवर्नमेंट का डिस्क्रिशन होगा. डिस्क्रिशन मतलब अपने आप के जुडिशियल माइंड या रैशनल से वो डिसीजन ले सकता है, ठीक है. However, some states have failed to create family courts. The reasons cited range from financial and space constraints to lawyers blocking any such move. Lawyers भी मना करते हैं कि हम छोटी छोटी सिटीज़ में नहीं जाएंगे भाई, वहाँ पर हमारा कोई ग्रोथ या डेवलपमेंट नहीं हो पा रहा है. We are not able to earn much financially, or we are not able to grow our personality much. They are अगर backward cities है या छोटी cities है तो उतना ही कम उनको awareness भी होगा of the laws or of any other matter. So lawyers don't want to go there, or financial या technological development नहीं है, space constraints है, means उतना space ही नहीं है कि हम as such एक court का establishment वहाँ पे कर सके, कोर्ट की बिल्डिंग वहाँ पर खड़ी कर सके, उतना स्पेस नहीं है. So these are some reasons which are cited by the state government for their inability to establish family courts in certain cities. Now, the fourth part, role of women, will be done in the next video.